A very warm greetings and welcome to Law and Life. This is Shashank Mishra as a host, present with renowned senior advocate of Supreme Court of India, Subodh Markandeji. In this channel, we discuss on the current legal issues that are happening in India, statutory law, and political history of India, and other related topics. Let's begin this session. Sir, in recent case decided by the Supreme Court, Justice Dhananjay Vaichanchud has sharply brought out the difference between a mere breach of terms of a contract and a criminal breach of trust. Shall we discuss it today?
Uh, I think, Shashank, you are referring to MNG Bhartish Reddy versus Ramesh Ranganathan, no?
Yes, sir.
Criminal Appeal number 1273 of 2022, decided on 18th of August 2022. There, the Supreme Court considered sections 405, 415, 420 of the Indian Penal Code and held that entrustment is an essential ingredient of the offense of criminal breach of trust. Is that so?
Yes, sir, that is the case. Sir, kindly describe this case in ample detail, sir.
So let us first look at the facts. At the relevant time, the appellant was the general manager of respondent number two, that is BSG Apollo Hospital, Mysore. Respondent number one, a neurosurgeon, worked with respondent number two hospital as consultant from 2004, uh, initially with a guaranteed monthly fee of rupees 50,000, which kept on increasing. And from June 2013 onwards, it was 4,25,000. A consultancy agreement was also entered into between the parties. That is respondent number one, uh, the neurosurgeon, and respondent number two, the hospital. So the consultancy agreement contained a clause to terminate the agreement by giving 30 days notice on either side, that is, either by the hospital or by the neurosurgeon, which might or might not contain reasons for such termination. Some differences cropped up between the parties. By his letter dated 9th of January 2014, respondent number one complained to the appellant that enquiry and reception counters of the hospital were diverting patients who were referred to him to other doctors. So this was his complaint, and requested that action be taken against the airing staff. On 30th of May 2014, the agreement was terminated by the hospital for inconsistent and unsatisfactory behavior of respondent number one. So on 31st of May 2014, respondent number one, that is the neurosurgeon, gave a representation to the managing director of the hospital, complaining about the gross irregularities in the billing of his dues. He also complained therein that appellant was threatening and maligning him. So thereafter, on 10th of October 2014, the first respondent filed a complaint under Section 200 of the Code of Criminal Procedure 1973 against the respondent number two hospital and its general manager, that is appellant. So it was registered as PCR number 2536 of 2014 on the file of the Court of Judicial Magistrate First Class, Mysore. So therein, respondent number one alleged that the appellant, in misuse of his authority, had terminated his contract with the hospital with oblique and ulterior motive of defaming him. Then another allegation was that as a result of incompetence of the billing staff of the hospital, fees to be charged by respondent number one was drastically reduced and he sustained loss on receipt of his professional fees. The third allegation was that appellant had assured respondent number one that the hospital would reimburse his fee after a thorough probe. And lastly, respondent number one was targeted by appellant and his henchmen. So there was no allegation that there was any misappropriation or anything like that. There was no allegation of mens rea. This is important as we unfold the facts of this case and the findings. So the judicial magistrate, by his order dated 3rd of March 2015, uh, registered the complaint and charging the appellant and respondent number two with offences under sections 120A, 405, 415, 420, 499, and 500 of the Indian Penal Code. Now, this order of the judicial magistrate was challenged before the revisional authority, that is, 4th Additional Sessions Judge Mysore, in criminal revision under section 397 of the Code of Criminal Procedure. So the revisional court passed an order dated 16th of December 2015, uh, holding that complaint did not disclose any ingredient of either the cheating or defamation, and consequently allowed criminal revision and dismissed the complaint. The matter was further carried to the High Court of Karnataka by the by respondent number one. So the High Court, by its order dated 12/7/2019, held that the ingredients of defamation did not exist. So first finding was in favor of respondent number one, that is doctor. But further held that material on record shows that the ingredients of cheating and criminal breach of trust did prima facie exist. So the appellant was aggrieved of this judgment and he carried SLP number 9509 of 2019 before the Supreme Court, in which notice was issued on 25th of October 2019. In pursuance of the notice, uh, respondent number one appeared and contested the case. So Supreme Court, after hearing the parties, allowed criminal appeal number 1273 of 2022, which arose from SLP number 9509 of 2019. So now let's look at the findings of the Supreme Court. The Supreme Court relied on a number of judgments and held, firstly, mere breach of contract cannot give rise to prosecution for cheating or criminal breach of trust. So this is the first finding. Then fraudulent or dishonest intention is a precondition. As I was saying, there has to be mens rea, no?
Yes,
So
sir.
fraudulent and dishonest intention is a precondition to constitute the offense of cheating. And criminal intention at the time of making the promise is the gist of the offense. What is the gist of the offense? Criminal intention at the time of making the promise. So that, as regards section 420, the court held that its ingredients are deception of a person, fraudulent or dishonest inducement to deliver any property, and finally, intentionally and intentionally inducing that person to do or omit from doing anything which he would have, uh, which he would not, or omit to do. Uh, so it has to flow from the uh, fraudulent dishonesty and inducement to deliver any property. So that's the crux of the matter. So after analyzing the complaint, the Supreme Court found that there were conspicuous absence of any allegation about any practice of deception or dishonest intention, or that the complainant was induced to deliver any property or consent that any person shall retain any property, or that he was deceived to do or omit to do anything which he would not have done or omitted to be done if he had not been so deceived. So that essential ingredient was lacking in the complaint of the doctor. That is why the Supreme Court concluded that there was a patent error of law in the judgment of the High Court. So, so the Supreme Court accordingly set aside the judgment of the fourth, uh, set aside the judgment of the High Court and restored the judgment of the revisional court, that is, fourth additional sessions judge. So, we take from this particular case is that while filing the complaint, you must include the ingredients of the offense, the mens rea, the deception, fraudulent and dishonest inducement to deliver any property, or intentionally inducing that a person would do or omit from doing anything which he would not have done but for the deception or dishonest inducement. So, since that was lacking in the complaint, the whole matter came to an end against the doctor.
Yes, sir, and that will be clearing all the doubts on the difference between mere breach of trust of contract and criminal breach of trust. Thank you, sir, informing all that, and that will be all for the day.
Thank you.